Okay. All right. Well, welcome everyone, and thank you for putting up with our technical glitches. I guess there's something that came out of this pandemic is perhaps we've all gotten a little bit more patient with managing technology. But I do want to welcome everyone, and I'm so grateful that you're here. This will be our last program for this calendar year. But we do have some really interesting programs lined up for the spring. One will be a program where we will invite you to help us talk about diversity among the arbitrator ranks and creating a pipeline of diverse candidates who are willing to go into the space of serving as a neutral with an arbitrator and mediator. And then related to that, we're hoping to do a program on implicit bias and how that impacts the discipline and grievance and arbitration process. And then finally, fingers crossed, we're hoping to have an outdoor, maybe luncheon program where we can do a little meet and greet with our new team from the NLRB that is in place. So certainly more to come on that. And I'll just go through our usual housekeeping details for this program. It is being recorded. Everyone's muted to preserve sound quality. Andrea's presentation will run about 20 to 30 minutes, and then she's more than happy to take your questions. You can either put them in the chat or we can unmute you. We'll see how that goes, but I know she is very willing to answer as many questions as possible. One note about the recording is that you do have to be a paid member of the Connecticut Valley LERA to access the recording. So if you haven't paid your dues yet, please do so. We will also make the slides available to you, and you will get a CLE certificate. So with that, I am going to turn it over to my friend and colleague, Andrea Barton Reeves from the Connecticut Paid Leave Authority, who's going to update us on the paid leave rollout and how it impacts Connecticut family leave and all the other questions that I know you have.
Great.
Thanks.
Thank you, Gail. Thank you, Bernadette. Thank you for having me today. So I will, in the interest of time, just share my screen and get our presentation going. And as Gail mentioned, it would be wonderful if you could hold your questions until the end, because that way I can just walk through the presentation, which may answer some of the questions that you have. So let me do a couple of things here. All right. So for those of you who don't know me, my name is Andrea Barton Reeves, and I'm the CEO of Connecticut's Paid Leave Authority. It is formerly known as the Paid Family and Medical Leave Insurance Authority, but we don't call it that for obvious reasons. I started in March of 2020, right before the pandemic hit. And before I came to this role, I was the CEO at HARC, which supports people with intellectual disabilities and their families. So today we'll talk a little bit about the authority itself. I think I took out for your purposes the slides about FMLA and CTPL. I have something a little different for you. We'll talk about the qualifying reasons, eligibility, how the application process will work, where you can find additional resources for both workers and employers, and a question and answer session. The Paid Leave Authority is responsible for administering the program. It was created by statute in July of 2019, along with the paid leave benefit itself. We have 5 primary responsibilities under the statute, and they include outreach and engagement, developing the policies and procedures that are needed to run the program. We established the trust fund, its contribution rate, and receive those contributions, which were the 0.5% that were collected starting the beginning of this year. We approve and audit private plans for those employers that would like to offer a private plan in lieu of the public plan with the approval from the Paid Leave Authority. And finally, we are responsible for administering the claims for paid leave benefits, and we opened the benefit application process last Wednesday. There are 3 key dates that you should be familiar with. Obviously, January of this year, we started collecting the 0.5% from worker wages and through their employers, and those have been deposited into the trust fund, which has a balance of a little over $300 million right now. Starting last week, Wednesday, we did open the benefit applications process for workers, sole proprietors, and self-employed individuals who have contributed to the fund. And starting in January, there will be an opportunity to then continue to submit applications, but then benefits payments actually begin next month. All right, so let me just talk a little bit about Public Act 1925, which has since been codified, but most people are familiar with it in this context. It did two things. First, it created the Paid Family and Medical Leave Insurance Authority and created paid family and medical leave, which meant we created an authority, a trust fund, and then it expanded the opportunity to receive paid leave benefits to sole proprietors and self-employed individuals. Then it also made significant changes to Connecticut's family and medical leave law by expanding it to employers with one or more employees, eliminating the hours worked requirement, offering job protection after 3 months of work rather than a year. It also expands the definition of family members to those related by affinity. It requires that an employer permit employees to keep up to 2 weeks of their PTO rather than forcing them to exhaust all of it to cover any time off they would be out for family and medical leave. And it also permits an additional 2 weeks of leave to be available if there is incapacitation during pregnancy. Who's covered by the paid leave law? Most employers who have one or more employees working in the state are covered by the Paid Leave Act and also covered by FMLA. Starting in January. It does include not-for-profits and private sector employers that have unionized workforces. Sole proprietors and self-employed individuals may opt in at any time. There is a waiting period through which you must make contributions. Our board just approved that yesterday. And if you opt in, you have to remain in the program for a minimum of 3 years. The contribution level is the same. It is 0.5%. And sole proprietors who opt in or choose not to opt in, they may do so individually, but if they are employing people, meaning issuing them a W-2, those employed individuals must have the 0.5% withheld and they have the right to participate in the paid leave program. Those that are not covered by the Connecticut Paid Leave Act include those that work for the federal government. Some employees that work for the state of Connecticut, including and those employees that work for municipalities or local or regional boards of education, unless they too have what are known as covered public employees. Non-public elementary or secondary schools are completely exempt from FMLA and the paid leave program under the new law. There are other entities that are also exempt from the law, and those include railroad workers because they are covered under a completely different federal statute. Those that are employed by governments of other states and employees of sovereign nations. So the two sovereign nations we have in our state that are commonly known as those that run our casinos, those are sovereign nations and those employees are exempt from FMLA and family and medical leave. And as you can see, there are a couple of other exceptions there. People who engage in interstate commerce but live in another state, and the spouses of active duty military members who are still paying taxes in their home state. Covered public employees include these categories: non-unionized employees of the state of Connecticut, and those that are unionized may collectively bargain to include themselves in the paid leave program. Employees of municipalities or local or regional boards of education have the option to participate in paid leave if the collective bargaining units in each of these workplaces choose to collectively bargain to participate. If they do so, then the union and non-union members of that workforce are then part of the paid leave program. Again, that's true for both the municipalities and the local and the regional boards of education. And you can see at the bottom of the screen that there is a pretty expansive definition of what a municipality is. It includes the towns and cities as we usually think of them, but it can also include a tourism district or a flood commission. How paid leave manages the contributions. The employee is remitting the 0.5% through their employer from their FICA wages. And there's a cap on those of $142,800. The employer remits those wages to the Paid Leave Authority, and we verify and validate the contribution amount through data that's available to us through the Department of Labor, the Department of Revenue Services, and other sources we have available to us. Those contributions are deposited into the Paid Leave Trust Fund, which is managed by the Office of the Treasurer. And it's from that trust amount and trust fund that the benefits for paid leave are paid. So let's talk a bit about the changes more specifically from that will occur as a result of the change in the law starting next year as it relates to family and medical leave. So as many of you know, if you were to take family and medical leave today, or someone of your staff would, it only applies to employers that have 75 or more employees for Connecticut. And they have an hours worked requirement of 1,000 hours and in 12 months of employment, after which job protection attaches. You can see here that the 16 weeks in a 24-month period would apply, and the 26 weeks of military caregiver leave would be available. The employer could require the employee to use all of their accrued time to pay for the time that they're away as a form of income replacement for family and medical leave. Starting next month, there will be significant changes to the law. That includes the application of the law to employers with one or more employees. As I mentioned earlier, there is no hours worked requirement that will go away, and job protection will attach after 3 months rather than 12. The time period that can be taken under family medical leave will change to 12 weeks in a 12-month period for all of the leave reasons that I will review shortly, except the 26 weeks of leave that's available for military caregiver leave will remain. And an additional 2 weeks of leave may be available if there's incapacitation during pregnancy. So let me just stop here for a moment and talk about that. The incapacitation has to occur during pregnancy, and it does not have to be related to the pregnancy. So if a woman is pregnant but she's had a chronic health condition and that causes an incapacitation and she happens to be pregnant at the same time, her healthcare provider can then determine that those additional 2 weeks of leave to which she might be entitled might be ones that she can exercise during her pregnancy. And finally, an employer can still require employees to use their accrued time off, but they have to allow them to keep up to 2 weeks of their accrued PTO. They may not require them to exhaust them as they can do now under the current law. A bit about the Connecticut Paid Leave Program itself. You'll hear us refer to it as CTPL, and it does stand for the Paid Leave Program, and we use to refer to the law itself, the agency, and the program. It is strictly a source of income replacement or wage replacement for those eligible employees who can't work for qualifying reasons, and it does not offer job protected leave, which is why we're clear to make that distinction between family and medical leave and the job protection that it provides and paid leave benefits. But you also hear us refer to it as PFML or paid family and medical leave. The reasons that a person can qualify or apply for FMLA leave and paid leave benefits are the same. So you can take it for your own serious health condition, and that can include serving as an organ or bone marrow donor and for pregnancy, as I'd mentioned, with that additional 2 weeks maybe being available to you based on circumstances. Bonding leave is also available. So you can form that emotional and physical attachment with a child who's new to your family through birth, adoption, or foster care. And it is available for everyone who is parenting. We have mothers and fathers here because that's the question we get the most. The most of both parents may take bonding leave. It can be taken for up to a year from the time that the child is either born into your family or placed into your family. Caregiver leave is also available, and as our population in our state is aging, we find that a number of people are applying for caregiver leave. As of yesterday, we had over 1,900 claims that had been filed since the week that we opened up claims, and 162 of those are for caregiver leave. The other qualifying reasons to apply for paid leave benefits in our state include qualifying exigency leave, and that can be taken under certain circumstances if a spouse, child, or parent is being deployed for active duty, for federal active duty. So that is not National Guard, but Army, and you're going overseas. Military caregiver leave is also available if a person who has served in active duty has been injured as a result of that duty. And that can be a psychological or behavioral health injury and a physical injury or both. So let me just talk a little bit about family violence leave, which is why I skipped it on the previous slide. Family violence leave is not an FMLA qualifying reason under state or federal law, but it is an eligible leave for paid leave benefits. And it is limited to 12 days, not 12 weeks as the other leaves are. And again, it is not a federal FMLA qualifying reason. Our state already has a Family Violence Leave Act, and people can take up to 12 days of unpaid leave to address issues arising from family violence. And that can include some of the issues that you see listed here: obtaining services from a victim services organization, finding housing, and the like, and shelter. Again, this is available in Connecticut. We're only one of 2 states that offer this as part of our paid leave benefit, and a person can apply directly to the paid leave program for payment. A special note about caregiver leave. You heard me mention before that our state is aging and we have 162 claims as of yesterday for caregivers. Today, caregiving leave can be taken for a parent, a spouse, a son or daughter who's under the age of 18, or if they're over the age of 18, if they have a disability. And Connecticut also allows for family caregiver leave to be taken for in-laws. Starting next month, the number of people and the categories of family members for whom this leave can be taken will expand significantly to include all of the caregiver categories that you see here, all the family member categories that you see listed here. So that includes grandparents and siblings and grandchildren. That is new. And it also includes people who are related by affinity. And that has a specific definition. That is any person with whom the employee has a significant personal bond. That's like one of these relationships in the statute, whether they have a blood bond or not. We often encounter this when we have families or couples that have lived together that are not married, and they need time to care for the other as a caregiver. If they were to try to take that time today, it would be ineligible for FMLA under state or federal law. Starting next year, with an attestation form that's completely filled out that will be provided by the Connecticut Department of Labor. And in those circumstances, an unmarried significant other could apply for caregiver leave under Connecticut FMLA and then also apply for a paid leave benefit while they're out on that leave for some form of wage replacement. The eligibility requirements for each of the types of leave are listed here. Federal leave, as we know, we sit here today, remains unpaid. There's still an hours worked requirement and an employment time requirement. We don't know how things will shake out with paid leave as we sit here today, but we'll just wait and see what happens. With Connecticut FMLA, as I'd mentioned, we have our job protected leave that attaches after 3 months, and the hours worked requirement is eliminated. To seek income replacement from the paid leave program, however, there is some residency requirements depending on whether or not you're a sole proprietor or self-employed individual. But let's start out by talking what the income requirements are, or the earnings requirements. You had to have earned at least $2,325 in the highest earning quarter of the past 4 of the 5 quarters immediately preceding the time that you apply for leave. You also have to either be currently employed in the state by what we call a covered employer. So that means if you worked for a municipality or a board of education, you would not be eligible because that is not considered a covered employer under the statute. So you're currently working for the covered employer, or if you no longer work for them and you're in a period of unemployment, you can still apply for paid leave if you're within a 12-week window from the time that you stopped work and through the time that you may be eligible for a paid leave benefit for a qualifying reason. Or if you're a sole proprietor or self-employed individual and you opted into the program, you may also seek the paid leave benefit. You still have the earnings requirement, and you also have to be a resident of the state to avail yourself of paid leave benefits if you're a sole proprietor or self-employed. The amount of benefit, or the length of time, I should say, that you can take your leave also depends on whether it's federal or state. Federal remains the same. You can take 12 weeks in a 12-month period. Now the Connecticut FMLA will be aligned with the federal FMLA with respect to the amount of time that can be taken, the 26 weeks for military caregiver leave, the 12 days for family violence leave, and as I mentioned earlier, the 2 weeks of leave for the incapacitation during pregnancy. The reasons that you can take job protected leave are also the same reasons that you can seek income replacement benefits through the paid leave authority. How would one apply for the paid leave benefit? You can start by either going online or by phone, and you can do that through our portal, which is ctpaidleave.org. 65% of the applications that have been filed to date have been filed through the portal. And people are doing that because once you create your identity on the portal, you create an account, you can view the status of your claim online, check your payments, upload your documents, and keep track of how your claim is progressing. Really are encouraging people to use the online process. We will observe 3 different kinds of leave and recognize, I should say, and honor 3 kinds of leave. The block leave, which most people are most familiar with when we're taking absences in chunks of time. Leave is also available on a reduced schedule. So that's for FMLA. And we also pay on a reduced schedule for paid leave benefits. And we also pay for intermittent leave as well, taking that leave in the separate non-consecutive periods of time. This is often to receive regular treatment. Sometimes it's chemotherapy, sometimes it's behavioral health, though we often see leave taken under those circumstances on an intermittent basis. The application process for a paid leave benefit works this way. It is the employee's responsibility to submit their application to AFLAC, and there is an employment verification form that an employer will be asked to complete. They will do that, and the employer or the employee can return that to AFLAC. AFLAC, who is our claims administration partner, will then notify that employee if there's any documents that are missing, and they will also inform them of their eligibility. They will receive a comprehensive checklist of all of the things that they need to provide so that when they turn in their application, it is as complete as possible. Once their application is approved, assuming they've met all the qualifications, then the benefit amount is determined based on the statute. So those that are earning minimum wage get 95% of their base weekly earnings. Those that earn more than that, there's a slightly more complex formula, but no one will get more than 60 times the prevailing minimum wage, which right now, excuse me, is $13 an hour. So the maximum benefit would be $780 a week. AFLAC is also responsible for issuing the benefits payments, and workers can elect to receive those funds in one of 2 ways, either through direct deposit directly to their bank account or through what we call a stored value or a Visa debit card. There will be no payments issued by check. Right now, payments are made 2 weeks in arrears. That was a suggestion that we got both from Washington State and from Massachusetts, but we may be shrinking that window because we're hearing that people would really like to get their benefits more quickly than that. And so we will do that. The reason we had a 2-week window is that it allowed us to determine whether or not a person is also receiving workers' compensation or unemployment insurance benefits, because if they are, that deems them ineligible to receive paid leave benefits, and there can be a bit of a lag, but we are probably going to close that window a bit. Here's just another way of looking at what the benefit calculation looks like. So for workers, I mentioned earlier, is earning minimum wage, they will get 95% of their earnings. So the math there is pretty simple. You can see what I mean when I said that the statutory formula for getting your benefit calculation is a bit more complex if you're earning more than minimum wage. But in the end, it is capped at 60 times the prevailing minimum wage, which is $780 right now. Benefits will be paid in this manner. So if you want to know how much you're getting, you can direct people to our website where there's actually a benefits estimator. It is a very rough estimate because there are a number of factors that play into whether or not a person gets a benefit and how much it is that they get. For example, a person can earn wages from a covered employer and then earn wages from an employer that's not covered. They may work for an employer that has for 2 employers, one of which is in the public plan and one of which has their own private plan. So there are different ways in which benefits can be calculated and eligibility can be determined. But in this instance, a person can go into this benefits estimator, put in their amount and get a general sense of how much they may get. And we've done this for both of the scenarios. As you can see here, a person earning minimum wage and a person earning more than that. The question we get the most is what happens and what does the integration look like between employer provider benefits and the paid leave program? Keeping in mind that an employer has to allow a person to keep up to 2 weeks of their leave, we walk through what we feel are really the 4 most common scenarios. So the first one is where a worker does not have any paid time off at all. They or any other bank of time or benefit that they can access, they would come directly to the paid leave authority after having their FMLA approved, and then they would be eligible for to apply for the full benefit amount for the entire time that they're out. There are circumstances where a worker is going to get employer provided PTO that is equal to the full amount of their wages for the entire time that they're out. And in that instance, they would not be eligible for any Connecticut paid leave benefit. Unless they exhausted that time, then they could come back at another time and apply for that benefit. We often get the question, why in the world would an employer ever do this? Employers sometimes do this, or often do this, to avoid what we call stacking, which is the ability to take federal leave and state leave and any other kind of leave that an employer may offer so that they can extend the amount of time that they are out. Some employers then require the person to use their PTO so that they can shrink the opportunity to have the stacking occur. In scenario 3, an employer may offer an employee some PTO, but it might be less than what they're making. And so therefore, they're not going to get their full amount of pay when they're out on leave. So the way that we would do that is that the person could still apply to the paid leave program for their paid leave benefit. We will pay them whatever the amount is that they're eligible for, and they can go back to their employer and seek some other form of compensation as long as that benefit amount does not exceed 100%. So if the person is getting their maximum amount of $780, we'll make the math very, very simple. Let's say they make $820 a week. They want to get that $40 a week difference. They can go to their employer, and the employer may say, you can use the hourly equivalent of your PTO to make up the 40 hours. You can take it out of another bank you might have available, and so on. So scenario 4 is where the worker is receiving some period of a blocked period of time for the time that they're away, and that's at their regular pay. And usually it would work like this. Let's say that a person has 4 weeks of paid time off. They need to be out on FMLA for 8 weeks, and they're allowed to keep 2 weeks of their time. So they would use 2 weeks of their PTO. They would keep 2 weeks, and they would seek paid leave benefits from the paid leave program for the remaining 6 weeks. And our payments would start when the 2 weeks that they're receiving in PTO stop. And again, employers often do this to avoid the stacking so that the PTO is being used and it can't be used to extend periods of time away from work. There are a few notes for workers. So the workers should confirm with the employer whether or not they will require or permit them to use whatever form of paid time off you take, if it's in banks of sick and vacation and other kinds of leave, and what the rules are about how this might work, whether they can use their sick time for caregiver leave, whether you require them to use PTO instead or their vacation time, and what the terms and conditions are of the short-term disability policy if one exists in your workplace. Because often the policy may say that the worker has to exhaust their employer-provided PTO and state-provided benefits, and they are the payer of last resort. That is a significant piece of information that we at the Paid Leave Authority would need, because it will determine when benefits are paid and how much. As I mentioned earlier, the worker responsibility when applying for paid leave is for them to initiate the paid leave benefit. And they have to let the employer know when they're starting, if they're going to begin a claim, which you'll know because you'll have to complete the employer verification form. And we really encourage people to create an account. They will be assigned a case manager that will walk them through the entire process. And that is the person that's assigned to them for the entirety of their claim. It is the worker that is responsible for letting AFLAC know and their employer know if there are any changes, if they need a longer period of time, if they're going to work sooner, if they're changing from reduced to block leave, if they're changing from block leave to intermittent leave. It's up to them to tell both AFLAC and their employer when the leave is changing. I'll talk a little bit about FMLA, even though I'm sure some of you are familiar with this, but we do have a lot of employers, because they are below that 75-person threshold or 50-person threshold, they're not very familiar with FMLA. This really is the purview of the Department of Labor, but we go through it because we have a lot of people that ask us a ton of questions about it. So for the Family and Medical Leave Act, that people will eventually come to you and say, I want to take leave, I have a serious health condition. The employee, by statute, has to let the employer know 30 days in advance if the leave is foreseeable, scheduled surgery, as an example, or as soon as possible, if not. The employer then has 5 days, once it's determined that the leave that's being requested falls under the Family and Medical Leave Act. It's not the same thing as an approval, but it essentially tells the employee in writing, it sounds like from you telling me you're having surgery, that's a serious medical condition that might be covered under FMLA, but I need more information from you, and you'll tell them what documentation is that you need, which is usually a medical certification form. The employee then has 15 days to get that form to you as an employer. You can extend that by another 15 days. If they exceed that time period, you can extend it a bit. Most employers don't, and they start the process again. Once you have everything as an employer, you have 5 days to let the person know whether or not their job protected leave has been approved, and you need to let them know how that leave works and what your rules are. Employers are responsible for tracking the leave to make sure the person doesn't exceed the 12-week limit. And the employee, again, needs to let the employer know how it is that they intend to return to work, or if they have any changes to their leave. And because it is job protected leave, the employer must return the employee to their job, same schedule, pay, conditions, and the like. I know many of you know this, but we just like to go through it. So even if an employee is approved for leave under Connecticut FMLA, they do have to follow all of the attendance policies. And we do like to remind employers that there may be other laws that also may be applicable to how the process may work and to an employee's specific circumstance. And I have some of them listed there. But we all know that in all circumstances, it is the employer's right and their responsibility to designate time off that qualifies as FMLA in order to preserve that job protection and to avoid any other legal complications. I've talked about a lot and tried to go through it fairly quickly, so I know there may be a lot of questions, but we do have some additional resources that are available on our site. There's a specific site for workers, and if you go to our site and you go to the process, which is here, and you hit that and it'll go to employees, there's an entire employee page that explains all of this. There's also on the site, as soon as you get to the home page, the application process for claims, so you'll find all of that there. For employers, we do have a plethora of information for you, so you don't have to do any of this yourself. We have what we call the employee rights poster, which is really a long form of everything I've spoken about eligibility, applications, all of that. There's a shorter form of that, and there's also an employee fact sheet that is more in a question and answer form for people that have questions about how the paid leave benefit will work. You are welcome to download these. I think we have close to 100,000 downloads on all of these documents combined. So clearly people are using them. The employer toolkit has everything you might want to know about paid family and medical leave from an employer's perspective, including private plans and lots of other information. The HR toolkit that you'll see there on the right side of the screen is more specific to how to implement paid family and medical leave. It does include the employer verification form. It also includes some sample letters that you can use and comparisons of how family and medical leave works now versus how it will work starting next month. So that we found that is a very helpful resource, and that alone, I think, has close to 20,000 downloads. So people are really using that. We are here to help. We do not have a call center, but we do have a contact us portal that you can find at ctpaidleave.org. So let me just go back a little bit to the website, and you'll see right here, we have contact us. That's where you can find the portal. And we do have a lot of frequently asked questions and helpful videos on our site, which is ctpaidleave.org. All right, so I'm going to come out and turn my video back on and see if people have any questions they want to ask in the chat or directly.
Yeah, Andrea, I think there were a couple of questions. You may have addressed these about the family violence.
Okay. Yeah. All right. So I see the question about the family violence leave is covered under paid leave only. It's not part of federal FMLA. Is that the question?
I think the question is about the interplay of the family violence leave under the paid leave law and the state statute.
Oh, and the state statute. All right. The state statute allows a person to take time off for family violence, but the 12-week period that applies to all of those other reasons for leave does not apply to the family violence leave. I was going to say the Family Violence Leave Act, but it does not apply to family violence leave. That is admittedly, by some of the drafters of the statute, probably a bit inartful. It probably needs to be pulled out and be in a separate section so that you can be clear that all of those other reasons, your own serious health condition, caregiver leave, and so on, those are 12-week leaves, and the family violence leave is a 12-day leave, but they're still all covered under the FMLA, okay, the new change to the law. So that, but it's limited to 12 days.
I have a question, Andrea. When you talked about the interplay with the employer-provided paid time off, is that agnostic to the type of time off that employers may provide? So, for example, if an employer provides sick leave and vacation and personal time, but maintains it separately, what you're saying is the employer can say, you can, you may have to use all your sick leave, or you may have to use all of your sick leave and personal and vacation, so long as at the end of the day, the employee is still left with 2 weeks of time off available. Is that a fair assessment? Okay.
That is a fair assessment. So we are agnostic, but I will say that the intent was the bias is for vacation time, because the reason that provision is in the statute is there is the feedback that the labor chairs and the labor committee heard from people who had exhausted all of their paid time to cover the time that they're away under FMLA. And then there's a family dream vacation, there's a destination wedding, there's a once in a lifetime activity that was happening for that person. So they either had to take a significant amount of time unpaid, or they couldn't go. So the reason why that provision in the statute exists is to allow people to have that time to participate in those important events. So the bias really should be towards time that you can use for vacation rather than sick. It's the preference, I should say, rather than the bias. Okay, so slides will be sent out. So let me just make sure that we're really understanding the family violence leave. It is because there's a couple of questions. All right. When I say it's under FMLA, what I'm referring to is that it is in the part of the statute that changes the FMLA for Connecticut, because that's just where it is. All right, that's what I'm talking about. It is not a part of family and medical leave, but when a person comes to you and asks for family violence leave, it is considered an entitlement. You can't tell them no, and they get up to 12 days, and they can apply for a paid leave benefit as a result of that. So it almost operates like FMLA does, which is why I keep saying that. But it is not one of the traditional qualifying reasons for FMLA, and it's not covered under the federal statute at all. So you can't run it concurrently.
There's a question from Zach about just asking a better recap on how it applies to municipalities and boards of elections.
It does not. Oh,
of education. Okay. Yep.
Yes, it does not apply to municipalities and boards of education. So let's say if a single employee or union negotiates, are all of them then eligible? The answer is yes. So it's not new, it's a bargaining unit. So it's not necessarily, so if there's a single employee in a bargaining unit, which I'm sure is happening somewhere, but I'm not familiar with that. But if the single person is in fact the bargaining unit and they vote to participate, then yes, the way the statute is currently drafted, that decision is binding on everyone who works in the program, everyone who works in that workplace.
Can I follow up with that?
Yeah.
Sorry, so then does that mean every employee of the Board of Education or municipality, or is it limited to that bargaining unit?
It's everyone in the workplace, whether they're in the bargaining unit or not.
You have a 3-person, very small bargaining unit, and they negotiate this benefit, then all 500 other employees of the municipality or Board of Education
are bound by it. That is absolutely right. I see the look on your face. I understand. But that is the way that the law works. Yes. Yes, that is correct.
I had a question, Andrea, if I may. Thank you for the presentation. It's very informative, very helpful.
Sure.
If you have an employee who is missing work due to an alleged or an asserted work-related injury, and they have a contested claim, whether it's through workers' compensation or perhaps through a short-term disability policy, but it's contested. So they're without pay, so they avail themselves of this benefit.
Mhm.
And a number of weeks go by while the case is being prosecuted or investigated, and at some point in time it's determined, yes, you should have been on workers' comp, or yes, the disability policy is going to award you benefits back to the date you started missing work. And let's say there's a 4-week back pay awarded in comp benefits or disability, short-term disability benefits.
Mhm.
Would the employee be expected to make restitution to the authority? And if so,
Yes.
how would that happen?
Absolutely. Well, it works in one, well, first of all, yes, they would be required to make restitution. And we do know that there's that gap, which is why we were trying to negotiate it with that 2-week payment, that 2-week window that we were talking about, the 2 weeks in arrears, to help us navigate that a bit. But sometimes that's difficult to do because it's just not long enough to give the other entities an opportunity to make a decision about what's happening. So we have an entire review collection process for finding that out with a relationship with the Workers' Compensation Commission, because we know there's no specific place where all of that information resides, so that we can pursue what we're defining then as an overpayment that has been given that person. So yes, they would be required to repay that money. We also have the ability, if they don't pay the money, to impose penalties as well, but we're just hoping it doesn't get to that. But we have the authority to do that if we need to.
Sure. Thank you.
You're welcome.
Andrea, there are some more questions in the chat.
Okay, let me take a look.
Great.
All right, let's see. The law provides that a union can negotiate to increase the benefit or just negotiate whether they're covered. That is an excellent question. So I think this all depends on, I'm hesitating because it can all depend on the employer. If the union votes to participate in the plan, it's usually participation in the public plan. So there's no increase in the benefit. You get what we offer in the public plan, which is the 95% if you're at minimum wage, and the cap it's at $7.80 right now, or 60 times the minimum wage if you're in the public plan. If you are in the private plan, then private employers and with their own plan can negotiate to provide benefits that are higher than any of the benefits that we offer. They just can't offer any less. And we approve the structure and the payments in the private plan. So if it's a union and a private employer, they can vote to participate, and that employer can dictate based on what we've approved, the terms and conditions of that payment. So it can be increased. So they can do both. If it's in the public plan, then they get what everybody else gets in the public plan. So I see another question. If someone starts their leave on 12/22/21, meaning now, are they required to use their PTO except for the 2 weeks? Well, the law doesn't change until January. So if they took leave right now, they would be subject to the leave as it currently exists. And then what the Department of Labor said, I want to make sure I get this right, so I may have to correct myself on this, is that when they start to bridge over into the next year, then the new law applies. So they may actually get some additional time, but the 2-week time period doesn't start until next year. So if a person, let me just see, also apply for short-term disability benefits, when can they get CTPL? Well, that all depends on the terms and conditions of the short-term disability policy. So the 4 scenarios that I ran through earlier, those are really the most common examples of how a short-term disability might apply. So if the policy says you have to exhaust all of your employer PTO and your state benefit first before you can get any payment for us, we have the payer of last resort, then that's the terms. Those are the terms and conditions. If the policy terms say you can get benefits at the same time, and it prescribes a specific percentage, then that's how that policy would work. What we do at the Paid Leave Authority is pay the person the benefits to which they are entitled based on their wages, which is that we have access to through DOL and DRS and some other databases. And then the person is responsible for going to their employer and figuring out what pool or pools they can determine any increase to the amount that we're paying if they're in fact entitled to that. Okay. So how does AFLAC determine the normal weekly wage? We do that because we have access to wage data from the Department of Labor and the Department of Revenue Services. And when you fill out the employment verification form, we're going to ask you specific questions about their scheduled hours, whether they're working reduced hours, and if they have access to any other kind of paid leave benefit, meaning short-term disability or any other pool. So we will take that and use that to determine how much their benefit should be. So let me just read this again. If we pay their normal hours, but they work somewhere else, does that mean? Okay, can this person come off of mute and if they can and ask me, because I don't think I quite understand this question.
Hi, this is Rita.
Hi.
Gail. My question is, yeah, if we pay their full normal scheduled hours, but they work somewhere else, does that raise their, so if we're considered paying them in full, they wouldn't be doing anything from Connecticut paid leave, I'm assuming, if they didn't work anywhere else, but if they do work somewhere else, they may be eligible for more pay, right?
That's right, they may be. So what it's total wages from all employers. And that is the wage amount that we use to determine what their benefit amount will be. Again, there's a cap to it. And that's why, because we often have people that work multiple jobs, especially people who are at or a little bit above minimum wage. We will find that and Gail is very familiar with this. You have folks that work in group homes and they'll work at a state group home, and then they'll work, for a few agencies. Some people have 2 and 3 jobs. So yes, but you as an employer are only responsible for reporting the wages with respect to the employment the person has with you. We at the Paid Leave Authority through AFLAC have access to all of the wage data from all of the employers, and we figure that out. That's not you don't have to be concerned with doing that.
Now, the scenario I gave earlier about the person starting on 12/22/21 for their leave, I do have this happening.
Okay.
She's going to be applying for short-term disability through the union. The union told her that she wouldn't be eligible for Connecticut paid leave unless she came back in 2022 and then went back out again in 2022. Is that right?
No, that is not right.
I didn't think so. I just wanted to make sure.
I love the creativity with I really am I am in awe, but no, it's not right. She can certainly have her leave bridge, but you know what? Can you email me? And I think Gail and I think Bernadette because I want to have a conversation with you and our general counsel, because it gets a little complex when we have bargaining units. I want to make sure that I understand all of the facts before I give you an answer. But no, you don't have to stop your leave and then start it again. That's not how.
I didn't think so. Yeah.
No.
And so we are running at the top of the hour. I do have one.
Thank you.
Sorry, Cody. With the caregiver leave, that is broader than the family leave, right? Oh my God, he's a nut. So in other words, if I wanted to take some time off to care for my in-laws, it wouldn't have to satisfy the serious medical condition under CTFMLA.
Yeah, so you would only be able to take time off if they have a serious health condition and you're taking time to take care of them to provide psychological or physical comfort or care for their serious health condition. So
they still have to meet the definition of serious medical condition. It's
yes,
just
they do.
Who it's applicable to is a broader category of people.
That's right.
Perfect.
That's
okay.
right.
Thank you. We have one more question before I let you.
Okay. All right. Let's see. Zach. Zach, why don't you know what? Why don't you come back on and just ask me the question? Because it'll probably take me longer to read it than for you to just tell me it.
I think it's Marilyn who posted the really long one, but it was a follow-up to Zach's question.
Okay, so Marilyn, would you like to just pose the question to me?
Sure. I was just following up on the question that Zach had posed earlier about if one small bargaining unit bargained in, does that mean all, for example, at a board of education at a school,
Mhm.
does that mean all employees are automatically covered? My understanding, just to clarify, is that the non-union employees would all be covered. So for example, if the administrators bargained in, the administrators and all the non-union employees are then in PFML.
That's correct.
But the paras, the custodians still are not unless their bargaining unit bargains in. Is that accurate? That was my understanding.
Yeah, so it is accurate, but what we've been telling municipalities or workplaces that have multiple unions is that it is really better for you to try to get all of the unions together, because to try to get all the unions together to try to get one decision around whether or not you're going to bargain into the paid leave, collectively bargain to be included in the paid leave program or not, because it really does get complicated. But technically, the way the law reads, if one union votes, that's binding on everyone else who is not in the union, but it isn't binding on all the other unions because one union doesn't have the right to collectively bargain on behalf of others. That's how it gets complicated. So technically you are right. So one union can say, we want in, we're in, all the non-union people are in, but then the other two bargaining units that are represented by other unions, they then have the right to make their own decision about what they want to do. I don't know if when the law was drafted, if complexity was ever taken into consideration, but as we sit here today, that's how it works.
Okay, thank you.
Okay, you're welcome. All right.
Well, I know
I've got to go. I've got people pinging me. Are there more? I'm happy to stay a little bit longer and tell them to wait and answer some more questions. It's completely up to you. We got a late start. Okay, Bernadette, I think Gail is gone.
anyone else?
It's okay. Bernadette, what would you like to do?
I think if there are no other questions, we'll go ahead and stop the recording and dismiss folks for today.
All right, great.
So thank you
you.
so much, Andrea, for coming and presenting
You're very welcome.
this information.
My
It was a
pleasure.
very knowledgeable for everyone here. So thank you so much
Good.
for taking your time.
Good.
Terrific.
Happy to do it again. Let me know. Barbara,
Thank you.
good to see you.
Yeah. Thank you, Andrea, for your
You're
time.
welcome.
And happy holidays to everyone. And we'll see you in 2022.
Exactly.
Take care. Bye-bye.
Care. Bye.